Greetings, my name is Patrick Phancao with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. Today, let's look at a specific element within the Medi-Cal qualification process. And the question is your home exempt for Medi-Cal qualification purposes? Let's go over some definitions and a bit of a background to give you an overview. First of all, in order to qualify for Medi-Cal, you have to be below a certain financial threshold, and it is possible that a home would be considered an asset which would kind of push you over the limit of the financial threshold and therefore make you ineligible for Medi-Cal. So the question is your home an exempt asset? Well, as in most legal dilemmas, the answer depends. An exempt asset is something that is excluded for qualification purposes, while your home is an exempt asset if you fall under one of these three categories. One, if you have the intent to return home at one point or another. Now, it doesn't matter whether it's 5 months, 5 years, or 10 years from the application process. The question is subjective intent. Does the individual intend to return home? Then, if you have a spouse or you have a child under 21 years of age that is residing at the property, then the home will also be exempt. And finally, if you have a sibling that has been residing at the house for at least a year prior to the application process, your home will also be considered exempt. So you might say to yourself, that's great, so I'm free and clear regarding the home. But let's make a distinction between an exempt asset versus an estate claim. So the home will not be counted against you once you apply, but upon your passing away, imagine that the Medi-Cal office has collected about $70,000 in medical bills for your care. Well, they would be allowed to turn around against your estate and make a claim for that $70,000. So in order to minimize the chances of an estate claim, the goal is to hold as legal or zero assets in your legal name upon your passing. So one way to do that is to make a transfer to your spouse or a child that has some type of disability, and that way there will be no legal title in your possession. However, in doing so, there are also other techniques, but in doing so, you want to ask legal counsel because you may trigger some tax consequences that you may not have intended. And let's address the issue, had you not gone to an attorney for Medi-Cal qualification and you had the unfortunate event of having sold your home during that process, well, there are some damage control things that you can do because there is a 6-month period of time in which you are allowed to go ahead and purchase another home, and that asset will be clear. So that is it for today. If you found this interesting, I know it gets a little technical, so go ahead and visit us and we'll send you a free report detailing this in more facts and give you more details. The website is www.assetprotectioncenter.com, or feel free to call me at 714-966-2646, and I'll be happy to discuss your situation. Thank you, and I will see you next time.